Hi, everyone, and welcome to Raw Law. We're here in my office in Brooklyn. This is attorney Arkady Frekhtman. I'm a New York City personal injury trial lawyer. And welcome, everyone. We're live. So what we're going to do today is we're going to listen to your comments, read your comments, and I'm going to respond and give you a free consultation. And if anyone is interested, you could actually also text me, and then I can give you a call and we can do a live consult. Of course, don't reveal your name or anything confidential that you wouldn't want everybody to hear, but you can go on live and we could do a discussion here right on the channel. We did it last time and I think it was pretty successful. It was helpful. And then I did a follow-up call with that individual and, I thought it was helpful. I was able to provide some feedback and which is our goal. Our goal is helping serious injury victims and families. So we try to help, we try to give you as much information as we can so that you could take that and use it to your benefit. So let me go into live chat and see what's here. And I see we have a question from Mauna Ratu. Hello, Mr. Arkady. Who initiates the settlement conference? Is that the judge or the attorneys? Thank you. Okay, yeah. So it could be either way. I mean, sometimes, usually I would say a settlement conference. Now, a conference is usually a court conference. So that would be scheduled or initiated by the judge. It's just one of the things that happens in court. But sometimes, an attorney can write a letter to the judge and say, look, I think a settlement conference would be really beneficial. And then the judge will just schedule the conference because the attorney asked for it, especially if a defense attorney asks for it, because he's basically telling the judge, hey, I spoke to my adjuster, I have money, it's reasonable, I've had some talk with the plaintiff attorney. I think the money I have could be enough to settle this case. And remember, the judge wants to get the case off his or her docket, because if the case remains on the judge's docket, then it's just there. It's more work for the judge. And then if these cases linger, then the judge is kind of like tasked with taking care of all these cases. And that's why, like, for example, a few years ago in Brooklyn, they had this really strict rule that once a case is beyond standards and goals, you either have to settle it, you have to pick a jury and start a trial, or he's going to dismiss it. Or sometimes the other option would be like the 325D it, which is to transfer it to a different court, from the Supreme Court to the civil court. So basically, they just want the case disposed of, because if the case is not disposed, I think it goes against the judge who's sitting in the jury coordinating part, because in the jury coordinating part, that's where the cases get sent out. So if the cases aren't getting resolved, then statistically, it's the judge's fault, right? And they track all these analytics, and then the judge could get in trouble. So they just want to get rid of these cases. So yeah, but to answer your question, yeah, I think mostly it's the judge, but it could be the lawyer too. And then we have a question from Mose 1977. Is a fender bender in a rear end car accident with a red light hard to prove your serious injury? Well, I mean, look, serious injury doesn't matter how the incident happened. Serious injury is just the injury. So they look at the injury. So it depends what the injury is, right? If the injury is serious, in New York, it gets a little bit complicated. There are 9 different categories, and I won't go through all of them. It's very boring. It's very tedious. But essentially, the easiest way to prove a serious injury is just to have medical care and to have an injury, like, for example, to have a herniated disc. And then they test your range of motion. Let's say you have a herniated disc in your neck. What's normal? Normal is, let's say, 90 degrees, right? And you have 70. So you have a 20-degree deficit. That's enough, right? According to the case law, as long as you have some kind of injury on an MRI, like a herniation or a bulge. So it's not that hard. Now, with a fender bender, if they're saying it's just a little fender bender and there's no damage to the car, that could be an issue. You want to have enough damage where you can argue, look, there's bent metal, there's something that this could have caused the injury. Because otherwise, they're going to get you on causation. They're going to say, okay, yeah, you have a herniation, but that could be from living your life, degenerative changes that everybody gets. But it's not from this. This is like a little fender bender, a little pimple, a little scratch, right? So you want to have something there that you could say, hey, this can be caused by this incident. And, you know, a lot of the time, the other thing is that you got to remember when you talk about cause and effect, right? Causation, in legal causation, you usually do not have to prove that the car crash is the only cause of the injury. What you have to prove is that the car crash was a substantial factor in bringing about the injury. So it just means it was a substantial factor. It was one of the factors. So for example, if you have like a boxing match, right? And there's a boxing match going on and there are 12 blows and then there's a knockout. Which of those blows caused the knockout? Well, all of them might have had a substantial factor, or all of them had a real effect in causing the knockout. And how do we know which one was more than the other? It doesn't matter, right? So as long as you can prove the car accident had this real effect or substantial factor in bringing about the injury, that's all you need to prove. And that's very important for a lawyer to understand. So yeah, so it's not that hard to prove. And then let's see, let's get some other questions answered. Larry Davis says, hi, Mr. Arkady. Hi, how are you? He says, if a ceiling fell on me in my bedroom and I didn't go to the hospital, but I got an attorney 3 weeks later and it's 100% their negligence, is that bad for my case? Okay, so a ceiling fell. So with the ceiling, you know, what you have to do is you have to show notice. So notice just means that you or somebody either notified the landlord and the management company, the people you would be suing, about this condition. So for example, it was dripping, or you saw a crack in the ceiling, you know, and you notified them about it. You said, hey, there's a crack in the ceiling. It's dripping. Something's wrong. And then some time passed and they didn't do anything. And then the ceiling collapsed. Well, now they're on notice because you actually told them, but they still didn't do anything. So there's three types of notice. There's actually notifying them. That's number one. Number two is constructive. If the ceiling just, you know, was in bad state of dangerous repair, or just in a bad condition for a period of time, then by law, maybe when they do inspections, they should have found it and fixed it on their own. Or the third way is if they caused and created the condition. So for example, I had a case earlier this week, somebody called me, they were doing work above in the apartment above, and the construction company was like breaking the, I guess putting in a new bathroom or something, breaking the floor, and they caused the ceiling to collapse. So that's caused and created, right? They caused and created the condition. So you need one of those three: actual notice, which is actual complaints; constructive notice, which is just nobody complained, but it existed for a period of time where they should have found it and fixed it; or three, caused and created, right? That's usually what you need for a ceiling collapse. With respect to liability, now with respect to damages, you just need an injury, just like any case, right? So you need to go to the you don't have to go to the hospital, but it's good to go to the urgent care, good to go to the doctor. If you didn't go anywhere for 3 weeks, they're going to say, well, you know, were you hurt? If you were hurt, how come you didn't go anywhere for 3 weeks? And also, if you got an attorney but you didn't get any medical, they're going to say, oh, you're looking to make some money off this. Why did you get an attorney? So you were hurt enough to get an attorney, but you weren't hurt enough to go to any doctors. You know, I could just see the defense lawyer. So yeah, it is bad, but you can fix it. Look, I wouldn't go there volunteering that you got the attorney. Maybe try to like put that on the back burner and you know, get some medical treatment. Get as much medical treatment as you can. Try to salvage the case. That's what I would recommend. Okay, and then Paul says, how long after an IME in a workers' comp case is a settlement reached? Yeah, so after an IME, you see, I don't really do workers' comp, so I couldn't really answer that. I don't know. I don't do workers' comp. All I know about workers' comp is in New York, workers' comp, the way it works is you get hurt on the job. It's just like you get benefits, right? You get lost wages paid and you get your medical bills paid. And then you could also do what's known as a Section 32 settlement, a lump sum settlement. But I don't know exactly the timetable in terms of like how long after the IME do you get the settlement. But I know that the lost wages and the medical bill checks start coming pretty quickly because you need that. You need your lost wages, how are you going to live, right? And you need your medical bills paid so you can keep treating. But the Section 32, I know, doesn't usually come. That's the settlement where you get the big money. That usually doesn't come quickly. That usually takes a while, maybe a few months or even years, because that's like a settlement of the whole case. The whole enchilada gets settled. So that takes a little longer. But I would defer to a workers' comp lawyer on that. But yeah, if you need a consultation or anything with a workers' comp lawyer, you could just text me. I know a bunch of workers' comp lawyers here in New York. I don't really know that many of them elsewhere, but I could maybe find one for you if you needed it. Okay, let's see. Leonardo's here. He says, hello, hi, how are you? Steven is here, and he says, if a large settlement is won by a jury and the defense files a motion for a new trial, can both parties try a settlement again to a reasonable amount? Okay. So then you mean a settlement doesn't get, but isn't really decided by a jury. A settlement is like a contract. It's an agreement between the plaintiff and the defendant. What a jury does is they award the amount that they think is the verdict. So they're basically giving you what's fair and reasonable compensation after a trial. So they get a form and it says, okay, was the plaintiff negligent? Was the defendant negligent? And if you say, hey, the defendant was negligent, was that a negligence a cause of the injury? Yes. Okay. State the amount that is going to compensate plaintiff for past pain and suffering, future pain and suffering, past lost wages, future lost wages, past, whatever claims you have, loss of consortium, future loss of consortium, past medical expenses, future medical, and then you add it all up, and then whatever the total is, like $1 million, and then that's what you get. That's the verdict. Now, yeah, if they appeal that, it's all up on appeal. So then the appellate court could reduce that. They could also throw the whole thing out and say on some technicality, some legal issue, do a whole new trial, right? They could say anything. Who knows what they're going to say? Or they could say it's a proper verdict. We're not going to disturb the jury's decision and just leave the case as is, right? They could say that too. So, yeah, but you're right. I mean, while that's all going on, while the appellate process is going on, you could totally reach a settlement, which is that contract where you agree. So, for example, there's a verdict for $1 million, right? And then the defendant says, $1 million, that's crazy. I'm going to appeal. And the appeal is going on. And while the appeal is going on, the plaintiff lawyer calls the defense lawyer and he says, look, you have this appeal. Who knows? You might win, you might lose. Let's talk turkey. And then maybe you settle it for 800 or whatever. That's possible. It's totally possible. In fact, that happens all the time. We've done that many times. Okay. And then Jonathan says, question, honorable man, how are you? If my case is like this myself and another 2 individuals, 26 million policy with Chubb, almost 2 years in litigation. When the case gets settled at any point, will the settlement be individually or together? So a settlement is usually individual because it's, personal injury. So it's your injury, your personal injury. If you have a case with other people, that might mean like you have multiple people in a vehicle. Let's say you're a passenger, someone else is a passenger. So you each get a separate amount of money. It's personal injury to each based on your injuries and your, damages and how it's affected your life. So no, you don't have to share that. I mean, it's not a settlement, like one settlement for everybody. And then he says, will a large policy like this, will it go to trial since it's a large policy, or will they settle quick? It's a rear truck accident. I mean, it's hard for me to say. I think that it depends, number one, where this is, right? Where is this? What stage is it in? How long ago did this happen? Did they file a lawsuit? Who's handling it, right? If you have a real strong trial lawyer, they might get scared and they might say, look, we have a $26 million policy, but this guy, when he goes to court, he gets like millions every time. I'm afraid, why are we going to wait and pay our lawyer all this money? And then when we go to court, he's going to hit us for like more millions. We're going to pay again. Why don't we just settle it now and just be done with it and move on, right? So remember, the insurance company wants to pay out as little money total as possible. But on the flip side, if the insurance company sees, hey, this firm doesn't go to trial, they're just one of these billboard firms like to advertise and say, have you been injured, and put on the commercials, and they have 20 lawyers, but they're all young kids. They've never even seen the inside of a courtroom. So they're not going to go to trial. So let's just, litigate it. Let's offer them a little bit of money. And what are the chances that they're going to go to trial? What are the chances they're going to hit us for like 10 million or more? There's no way, right? Because they never go to trial. So why should we pay? Let's just keep our money. So they know all this. They're very smart. They're billion-dollar companies, right? So they have statistics on all these lawyers. So that's usually how they operate. So they look at it as a business. So you have to look at it. You have to flip, like reverse roles with them and look at it the way they look at it, right? Look at it through their eyes and think, if you were an insurance company, what would you do? That's why I always tell people, it's really important to hire a trial attorney right away, a good trial attorney who has a proven track record of getting multi-million-dollar verdicts and trials, settlements, verdicts, goes to court, isn't afraid, because these settlement lawyers, they're just like writing letters and then they're picking up the phone. It's like dialing for dollars. Whatever they give you, they give you 10,000, then they call the client. Oh, 10,000, that's a good number. They give them 3,000. Oh, 3,000, that's a good. They're just like basically calling the adjuster. Whatever the adjuster says is the settlement. Then they just call the client and try to force it down their throat. That's not really being a lawyer. That's terrible, So I would need more information, but just text me 347-566-9595. Or like I said, if anybody wants to do a live call, you could do that as well. We'll keep your name confidential. Just, tell me the brief facts of what happened. Tell me your injury, which is kind of like, basically talk about whatever you're okay with people hearing, but nothing, common issues. Like, for example, rear end crash. I had a fusion or whatever. I had a broken bone. But those are just common issues that a lot of people have, right? So people would be interested in that, but nothing confidential. Okay, let's see. So we did that one. And then we have relaxing tones. Rear-ended by a truck in Florida in December of 2022. Back and neck injuries, ACDF at C5, C6, bilateral SI joint fusion, and a laser discectomy in the L5S1, plus block injections, ablations, 6 months of PT. Yeah, that's really serious. I mean, those are serious injuries. That could be a big case. That could be, it's hard for me to say from a comment, but that could be a multi-million-dollar case, like even worth, 2 million, 3 million or more if it's worked up the right way. That could definitely be a huge case. I've had cases very similar to that, like with trucks, with fusions, and I had one in the Bronx in New York, 2.4 million. So yeah, and I've seen other cases, it could even be more than that. It really depends on the overall damage, right, to your life, like the full human story and the overall, not just the injuries, but the injuries obviously are an important component of it as well. Okay, and then Jonathan says, sorry for all the questions, but this is driving me crazy. It's already been 2 years and I'm waiting for more discovery. Yeah, no, I'm sorry to hear that, but just text me, 347-566-9595. Oh, yeah, it doesn't have to be live. You could just text me. We could just schedule a consult. I did some consults today. I was going to do 1 or 2 more, and then tomorrow for sure as well. I'm trying to catch up for the week because I haven't been able to. I've been a little busy with like paperwork and some clients and other stuff. So I'm trying to catch up just to do all my consults for this week. But yeah, just text me. Just the only thing I ask is when you text me, just include your name, the facts of what happened. It could be brief, like just 1 sentence, 1 or 2 sentences, just so I can have like a picture in my mind of what actually, happened. Like, for example, it was a rear end, or it was a slip and fall on a puddle, or whatever it was. And then the injury, like if you know the injury, like, fusion, like the gentleman just said, or the lady, relaxing tones, like the person just said, like that, that's perfect, right? ACDF, SI joint, whatever it is. And then also the date of incident, when it happened, and your city. And that's really all I need. And I even have a form. I could send you the link if you'd like to fill out the form, or you could just send me a text, because the form just has the same information as that, just facts, injuries, date of incident, and yeah, so that's basically the same thing. So yeah, and then I have a little bit of an idea about what it is. Then we can do a call. We could schedule a call. And, oh yeah, and the last thing, tell me like what times are good for you, because I like to schedule. I like to add it to my calendar, because getting busy. If it's added to the calendar, then it's like I'll call you for sure. I'll remember. I'll look at the calendar, and we get it done. Okay, and Dory says, can you give any insight on what status conferences and so ordered entails? Yeah, so when you have a personal injury case, when you have a status conference, you just want to check the status of the case. It's kind of like the same as a compliance conference. So the first conference in a case is known as a preliminary conference or a scheduling order. So they schedule things. For example, the plaintiff has to give discovery to the defendant. That might be medical records, right? The defendant has to give discovery or documents to the plaintiff. That might be a copy of the property damage of the cars, photos, if it's like a slip and fall, it could be video surveillance, whatever the plaintiff asks for, right? And the defendant has. Then you have deposition discovery, which means the plaintiff questions the defendant. The defendant questions the plaintiff. How did you get hurt? What are your injuries? What doctors did you go to? And the plaintiff questions like, the superintendent or the driver of the truck that hit him, or, the defendant. Then you could also question non-parties. That's all known as discovery. You're basically discovering information. And then the court is just kind of like overseeing that. Now, they don't really do much, the court. They just kind of sit by and let the lawyers do it. But if you have an issue, you make a motion for like sanctions, for change of venue, for if they're not giving you documents that you think they have, you ask the court to force it. So these status conferences are just to check on the status of discovery usually, because once discovery is done, you certify it as trial ready. Now it's on the trial calendar, and now it's already certified as trial ready. Now it's just waiting, and then you're going to get a trial date eventually, right? But before that, they want to check the status, or sometimes they call it compliance conferences. Did you comply? Like, for example, if the judge says do depositions by November 1st, did you do that? November 1st, did you do depositions? They want to comply with the prior order. Did you comply or not? And then so order just means that if you stipulate to something, like for example, if I say I stipulate to give them, an authorization for ABC doctors by November 1st, right? And then the defendant says, okay, thank you that you stipulated to that because that's what we demand. Now the judge says, okay, it's a so-ordered stipulation. So it's not just a stipulation between the parties, but it's also an order from the court. So kind of like you're going to have to do that. You're going to have to give them that. But that's all it is. Okay. And then Derek is here. Hi, how are you? And Larry Davis says, I gave them an 8 to a year notice about the ceiling. I sent photos, I sent emails, and all I got a discectomy on the neck and back and an ACDF. Oh, wow. Yeah. So if you had all those injuries, that should be a strong case. If you gave them a year notice, you complained to them and, all that. Yeah. With the discectomy and an ACDF, that should be a strong case. I wouldn't worry about, starting treatment. I thought you meant like the incident just happened like now. And I said, don't wait in that case. But if the case has been going on and you have a fusion, I mean, you could explain that away. You need to come up with a reasonable excuse for why you didn't get medical care right away. They're still going to argue 3-week delay, but you could just say, look, I thought it was going to go away. I gave myself a chance to heal. You just got into a ceiling collapse. Nobody wants to admit or, accept that you're going to be like a life-changing forever injury right in the beginning. You're going to, say, no, I'm going to get better. You give yourself a few weeks, but when you see, hey, the pain's not going away, then you start medical treatment. So you just have to explain that. But yeah, you should be fine. That's a good case. And then Jonathan says, my lawyer told me we were near for them to start a conversation on the case for settlement, mediation, but it's a large policy. I don't know what to believe anymore. Oh, yeah. Well, yeah, it's hard for me to say. Like, just text me. Like I said, if you text me, we could do a consultation. It's free. It's confidential. And, I could answer all your questions. I could even look up the lawyer and send you their verdicts, their settlements. If they're a trial lawyer, I could look up. If it's in New York, I could look up the case in the court's computer and tell you all what's going on with the public filings, whether they're, basically what's happening with the case. Because most of the things are in the court's computer. You could just access it. So I could look at it. It's a public file, and tell you, and then based on you telling me, I can give you some input and then help you in any way I can. Preacher says, is it normal for a lawyer that works in a law firm with other lawyers to go over a demand letter before sending it to a defendant? So a lawyer that works in a law firm with other lawyers. Yeah, the lawyer usually drafts the demand letter. And then sometimes if it's like a more senior lawyer, like a trial lawyer that has their own caseload, they might not have to show it to anyone. They'll just send it. They should probably discuss it with the client. What I like to do is I like to do a call with the client and find out how the client has been impacted. And then I put that in the letter. But not everybody does that. Some people just do like the standard letter where they just say, oh, I have a herniated disc and give me money, and just send the boilerplate letter. It just depends. Everybody has their own their own style or their own. But yeah, junior lawyers, I would say, like somebody who's a little bit more green, they usually do show the letter. Like to me, I'll review it, or they'll show it to one of the other senior lawyers in the firm. That's a good idea, just so you have more people collaborating on it, making sure it's proper. But yeah, like for example, today I was speaking with somebody. We have a trial coming up, I think in mid to end of November, and it's a small policy. And they're giving us money, but they're not giving us the entire policy. And so I was going to send a letter, but I thought instead of me just sending a letter, why don't I speak to the client? So I did a Zoom call with him, and actually it was really, really helpful. I found out that he had to leave his job, and he has like a whole other jobs, and he had to start quitting job after job because, he just couldn't physically do the work. And then his life changed. He used to play sports with his son, football and basketball. And now his son just, he couldn't because he had a back surgery on his lower back. He was hurt, couldn't do it. And then his son lost interest in sports. So you could see it doesn't just affect the person that's injured, but it affects the whole family. It affects like friends and relatives. And then he couldn't do things like for his wife instead of him, helping like with the laundry and things like that. Now, the son, he was only 12 when this happened, he had to go and carry the laundry, and he felt instead of feeling like the man of the household, he started feeling like a burden. So everything changes. So, but you wouldn't know that unless you did a deeper dive. So it's really important, I think. Yeah. Okay. And then Steven says, if you can't find anything about a lawyer on a verdict search, what could that mean? Well, it doesn't really mean, it depends on which, there are a few different verdict searches, right? There's Westlaw, there's Lexis, there's also the ALM one, which is a big one, like the verdict search. I think that's ALM. That's the big one that they have. It's called verdict search. If there's nothing on there, it could mean the lawyer's not a trial lawyer. He's not doing trials. Or it could be that they did some trials, but it didn't get reported. But you figure, like, if it's a lawyer that has been around for a while and there's absolutely nothing, probably it means that they just haven't done too many trials, because usually you do get something reported in one of the databases, And then Medicated Bob says, I have a crazy dog bite at a business. Oh yeah, I'm sorry to hear that. I've done a few dog bite cases. Those are tough. Those could be tough, but you could get serious money on dog bite cases as long as there's insurance. You could do well with dog bite cases. And Jonathan says, thank you. God bless you and your family. Oh, thank you. I hope you feel better. And yeah, like I said, just text me. I'm happy to do a consultation and help you. And then Moes 1977 says, first offer was $72,000 for a percutaneous cervical discectomy before doing a deposition or filing the lawsuit. My lawyer said he needed to file the lawsuit to get the $250 policy limit. Is that right? I mean, it could be. Yeah, 72 is a good start. And then if you have 250, you might have to file the lawsuit and say, look, I'm looking for the entire 250. You could also play tough and say, look, here's a settlement letter, pay me the 250 by, within 30 days, like by November 17th. And if you don't, then it's not going to be 250 anymore. It's going to be 750, and really put pressure on them, make them pay you. And if they're not going to pay you, stick to your guns and try the case and get 750. Show them who's boss, like show them that this is worth money. And don't play games with me. Don't lowball me. You got to be tough with these insurance companies. And then Larry says, and I have my reason I didn't go to the hospital right away, and it was a 2-level fusion, and been going to PT for over a year. Oh yeah, no, 2-level fusion is very serious. That should be a multi-million-dollar case. That's a good case. And Mastermind says, in Kings County, a rear-ended by a tractor trailer, 2-level fusion, needs shoulder surgery, and they hurt my back, a pre-existing injury. What is the fair settlement? 2.5 to 3 million? No lost wages. Okay, so you got Brooklyn venue, that's Kings County, New York. That's a good venue. Rear-ended by a tractor trailer. Now, as long as they have the coverage, right? Because some tractor trailers only have 750, some only have $1 million. So you have to go to like the Federal Motor Carrier Safety Act. They have something called SAFER, where you could log in and you could actually do a company profile. One of the things they tell you is the number of power units that they have. So if the company has, let's say, 40 trucks, well, then yeah, probably they're going to have $1 million, or maybe even with a 10 million excess. But if they have one truck, they might only have 750. So you want to know how much they have. But if they have the money, yeah, I mean, 2-level fusion, and you're saying you need shoulder surgery, but you haven't had it. Depends on what type of shoulder surgery. If it's like just an arthroscopic, that could add another, $200,000-300,000 to it. And then you re-injured your back with a pre-existing injury, but we need more specifics. Like, what was the pre-existing injury? How did it get worse, right? How was it made worse by this truck crash? So we need those specifics. But yeah, I would say fair settlement could be 2 to 3 million. It could be more, The best thing to do for like specifics is just to text me, 347-566-9595. I'm happy to chat. That way we could figure it out together. And then Colby says, I have a cervical spine injury. I was T-boned by a car that pulled out onto the highway. I have a herniated cervical disc. How much is my case worth? I have $1 million policy. If the responsible party's insurance reaches its max coverage, would my UMI policy kick in? Oh, you mean like uninsured motorist? UM? I think he means UM. Yeah, it could kick in if you reach the million, if you have one. Yeah, it could be. Like SUM, it's possible. But I mean, it's hard for me to say how much it's worth because I don't know like where you are or how the injury has affected you. I'd need to also, I'm just actually saying it, but it kind of gets like granular. It kind of gets specific. So if I was just throwing out numbers, I know people like to hear big numbers. But I don't want to give you like false information. So really, like I'd really need a consultation. Then I could tell you, of course, and also like I don't know values all over the country, right? So in New York, it could be worth $1 million, but in like Tuscaloosa or whatever, or in Alabama or in Mississippi, maybe it's worth 30,000. I don't know, right? The values are all over the place. So, but I would say in New York, where I practice, a cervical spine injury, you got T-boned by a car. And you have a herniated disc. I need to know more though. I mean, if it's just a herniated disc that's soft tissue, it could only be worth like, 20, 30,000. Now, if you had injections for it, if you had percutaneous discectomy or a full-blown like micro discectomy, it could be worth 500,000. If you had a full-blown surgery, it could be worth 2-3 million or more. So it's hard to say just from saying I have a herniation, right? Because then everybody who said I have a herniation would have the same value. Of course they don't, right? Some people have a herniation and they settle it for 5,000. And there was a guy in the Bronx who took a soft tissue herniation to trial, and he actually hit for $5 million on a soft tissue herniation. So one guy has a herniation, he got 5,000. The other guy has a herniation, he got 5 million. So how can you say all herniations are worth the same, right? They're not. So each case has to be taken individually. So yeah, but yeah, just text me. I'm happy to chat. And then Hector says, in what kind of situations does the other parties mediate early for a pedestrian accident? Yeah, I mean, usually if it's a serious injury and they see that the potential liability, meaning the potential, verdict that they're going to get hit with is much more than their policy. Like, so for example, a car hits a pedestrian, the car has 100,000 in coverage, but this pedestrian has surgeries, this pedestrian is really hurt, and the lawyer can go to court and get $1 million. They don't want to really risk that because they're laying out their insured, their policyholder out to dry. And they have a duty of good faith and fair dealing to their policyholder, right? Because that's the whole idea of insurance. The policyholder is paying, let's say, whether it's Geico or Allstate or whoever it is, he's paying the insurance company for this protection. He's paying premiums in exchange for this protection that if he somehow, looks at his phone and hits somebody, a pedestrian, that this, whatever he has, 100,000, they're going to use that 100,000 to pay the claim. They're not going to say, oh, even though, we have 100,000 in coverage, just take 1,000. Then the guy's going to say, what are you talking about? He's going to get pissed. He's going to get a lawyer. They're going to go to court. They're going to hit for $1 million. And at that point, the insurance company is going to say, okay, well, here's 100,000. And the lawyer's going to say, no, I don't want 100,000. What about my other 900,000? I want the verdict. And then he's going to come after you. So, and you're the insured, you're the policyholder, you're paying your premiums. Why should you get screwed? Because the insurance company wanted to be cheap. You see what I'm saying? So that's the whole idea behind it. So you have to use that to really push the insurance company and remind them about their duties, because they forget. They need to be reminded, they really need to be reminded about their duties, their fundamental duties to protect their policyholders. Okay, so let's see. So we did Hector. We did Colby. Aquatic says, with accepting a certain amount of liability for property damage caused me to lock in the same liability to my injury portion of the case? No, not usually. I haven't really seen that as an issue. I know sometimes like we have a case and, we try to get 100% property damage, but the adjuster for whatever reason is just being like cheap or being unreasonable and says, look, I know 100,000. I know 100% would be us paying you, let's say 20,000, but we're only going to pay you 10,000. But that doesn't mean that when you go to a jury, you're now somehow limited to only getting 50% liability, right? The jury doesn't know about your property damage settlement. So it could be anything. It could be the full 100%. So yeah, it doesn't really affect you. And then Leonardo says, some law firms are defense lawyers and plaintiff lawyers at the same time. Yeah, some people do that. I mean, that's true. Some people do that. You can't do it, obviously, for the same. You have to have no conflict of interest. So, for example, like you could be a defense lawyer for one insurance company, but then you're not going to take plaintiff cases against that insurance company. So, for example, I think I had a friend. He actually used to work here, and he's a plaintiff lawyer. He opened up his own firm now. He's a pretty good lawyer. So he's mostly a plaintiff lawyer, but then at one point he was doing defense work, I believe, for one of those small carriers like American Transit, the one for the yellow cabs that's going in liquidation. I think he was doing defense work for them because that way he gets trial skills, right? He goes to court, he tries cases, and he doesn't want like any plaintiff American Transit cases because they never pay and they take like a decade and now they're going bankrupt anyway. So it's actually a good gig, right? He's getting paid and he's getting experience, and then it hones and sharpens his plaintiff skills. So actually, smart guy. That's a good thing to do. Okay, MVP Digital says, I just had a 2-level cervical disc replacement last month and still have a meniscus tear on the right knee and tears on the elbow and wrist. How much do you think my case is worth? I'm going against the NYPD. Yeah, so with the NYPD, that's the city. So if you have a 2-level cervical disc replacement and you said a meniscus tear, I mean, yeah, it's hard. Again, it's hard for me to say. I'd have to look at the case and evaluate everything. But just if you want a quick, like, don't hold me to it. I don't know. Like, nobody can really give you an answer from a comment. But I've settled cases with the city, like with disc replacements or fusions for. I had one with a slip and fall for 1.4. I had one with a car crash for 1.5. I had one with, that one wasn't the city. That one was Con Ed 2.2. But yeah, people are getting pretty good numbers with the city. The only thing with the city is you really have to prepare it for trial, and you probably have to start the trial. And then while you're in the middle of the trial, that's when they pay the real money. They usually don't pay anything they give you earlier is going to be like 10 cents on the dollar. So you got to make sure you have a real trial lawyer and you're willing to go all the way. And then Aquatic says, Florida bike case, 3 herniated cervical discs with impingement to the nerve, partial tear to the rotator cuff, and broken ribs. $100,000 liability policy. It was on the sidewalk. Well, yeah, if you have all those injuries and it's only 100 policy, I would ask for a quick tender. If they don't tender it, just do a bad faith and say, look, if you don't pay me the 100, then it's going to be $1 million, and go for it. And just as long as you have a trial lawyer, you should be fine. And Colby says epidural injection shots. Okay, yeah, epidural injection shots are pretty serious. Yeah. That's pretty serious. Those are, they only do those when you have a real serious pain and real serious injury. And then Frost Midnight says, is it normal for a trucking company to taunt a victim or, I guess, show no sympathy through social media posts? I guess it's about putting business first before anything. I mean, no, it's not normal. They shouldn't do that. But you should record that. And then actually you could use that against them, because if you're suing them and you have a case and they've hurt you, and you have a strong, like, substantive case, a meaningful case, a case of merit, and they're taunting you, you could use that against them. You could show, hey, look, instead of being fair, look what these guys are doing. And I think he's saying it's an Alabama case, but I hired a law firm in my state of Georgia, and they said they will team up with an Alabama firm. Yeah, I mean, I really need to know, like, how the incident happened. Like, is it a truck crash? What happened? What are your injuries? Just all the, staples, all the basics, like the foundation, then we can get into, like, because when you talk about, like, they're putting a post on social media, that's like, imagine you're talking about, like, the trim on a window, but I don't know what the house looks like, So first I need the foundation, the house, then you can talk about trims on windows and what kind of awnings and what kind of drapes and all that stuff. But you know what I mean? Like, first you need to know what the case is about, and then I can give you more input. Okay, Aquatic Shock says, and also trigger point injections. Yeah, that sounds like a serious. But the CDF, the CDF level 2, ACDF 2 level from a specialist, that's going to be the biggest injury, right? Because that's a serious injury. You're talking about an anterior cervical discectomy and fusion. That's a back and neck surgery. That's a major surgery, and they're putting in, like, hardware and everything. That's serious. That's going to give you the most value. Colby says, thank you. Oh, you're very welcome. And Frost says, if a truck accident case with $750K and then the injuries are life-changing and they tender the policy limits, would the lawyer take the percentage out of the 750? The law firm I hired has a track record of policy limits. Oh, I see. I must have missed that comment. Okay. So it's a truck accident and the injuries are life-changing and they want to just tender. So all that, just make sure they don't have any excess or umbrella. You know, sometimes if they do, you don't want to just take the tender, right? Because then you're leaving, what if they have $1 million excess? But, you know, with 750, they might not. So as long as you get an affidavit from the company, from the insurance broker, from everybody, that they don't have anything else, all they have is the 750, then you can take it because that's all they have, right? There's no more. So you're getting everything that they have. That's fine. And you're saying, would the lawyer take the legal fee? You're talking about the percentage? Yeah, I mean, he'll take the legal fee off whatever he gets you. So if he gets you 750, he'll probably take a third of that. That's the contingency agreement with all lawyers. And then Aquatic says, we'd just like to say thank you very much for the time you spent doing this. You're a blessing and you have a ton of knowledge to us to be able to navigate the legal system and not get taken advantage of. Oh, no, you're very welcome. You're very welcome. That's what it's all about. I want to help people as much as I can. You know, it's all about helping people and doing the best I can to, you know, to share this knowledge that I have and to give back, because I feel like that's what it's all about, right? If I'm an attorney and I'm a civil justice attorney, ultimately I'm helping injury victims, right? I'm helping them, I'm helping their families, I'm helping them like rebuild because they've been kind of like knocked down. They have to overcome this huge obstacle in their life. So I want to help them do that. So that's what it's all about. It's very rewarding to be able to help people. And that's what it's all about. And Lost in Awareness says 2 lives in 1 week. We can get used to this. Yeah, I was trying to do a little bit more lives, you know, just because I didn't have a chance to record as many recorded videos. So I think we're running low. Probably maybe next week, or I'll record a few videos. If anyone has any topics for the recorded ones, I'll try to do a few of those as well. And MVP says, thank you very much. And then Mastermind says, I know how you say the attorney you hire is important. I learned that my trial lawyer is a trial lawyer at the federal and state level and appellate court. Is this a strong lawyer? Yeah, I mean, it could be. You know, the best way to do it is to, you know, like maybe research them and research their past history of actually going to court. And when they went to court, what happened, right? Did they get, like, for example, they go to court like 10 times, 8 times they got, you know, $1 million or more. I feel like my case could be $1 million or close to $1 million. So I'm happy with that. But if I have a lawyer, hey, he went to court 10 times, 1 time, you know, 5 times he got 0, 4 times he got like 4,000, and once he got like, you know, maybe 100,000. Well, now I'm like, oh, I don't know. It doesn't sound so good, right? Because what are the chances that my case is going to be the first case he gets $1 million? You know, if he hasn't done it in like 20 years, right? I mean, it's possible, but you know, that then it's already kind of like not so good, right? Just like anything, right? Just like a doctor, you want to make sure if you go for like a surgery, you want to make sure, hey, the guy's done surgeries before, he knows what he's doing. It's like he's gonna do brain surgery. I'm gonna be the first brain. Hopefully he knows what hopefully it goes well. Let's see. You know, you don't want to be a guinea pig. Okay, and then Frost Midnight says, does an insurance company ever use your videos in court? No, not my videos. I mean, they could use video. The way they use videos is, for example, if they record the injury victim, right? So, for example, if you testify, hey, I can't, you know, do something. I can't go shopping. I can't lift these shopping bags. And now they have you, right? They have the transcript. They ask you, what can you not do after your accident? I can't lift shopping bags, right? So now they have a transcript of that or a video deposition of that. Now, then guess what? Like a month passes and they have this private investigator with a big angle lens sitting there following you around, and he gets you at Costco or he gets you at whatever, Trader Joe's, at any supermarket, and you're out there with like carrying like 5 bags. They're really heavy. Now they're going to use that video. They're going to show the transcript where you said that. They're going to say, look, the guy's lying. He's lying because he wants to get more money. That's the kind of thing they could use in court, but not like my videos, because my videos are just educational, you know. Okay. Colby says, this is awesome. Thanks a lot. Oh, you're very welcome. Lost in Awareness says, is it common to have a mediation and the defense lawyer didn't give the adjuster all of the necessary information to settle the case? Yeah, I mean, it happens. You got to understand, like, defense lawyers are human too, right? So they get busy. They have a lot of cases, and sometimes they miss things or they don't, dot every I or cross every T. So it happens. And if they don't do it, then basically the adjuster can't settle the case. But you could just adjourn that, and then they'll do it, and then you'll settle the case later. Yeah. So, and then Digital Audit says, I have 10K MedPay and sent in my bills 6 months ago, but 12 months later, I'm not being paid. Is that standard? How long? So you have MedPay and you sent in your bills. No, you should be paid. I mean, there should be a reason. So you should just ask your lawyer, hey, send them a letter, give them a call. What's going on? There's got to be a reason. And Carve Life said, in the medical malpractice, if a doctor has retired, is their past insurance company still liable? Yeah, so the way that works is it's from the date of the incident. So for example, if a doctor, let's say, makes a mistake at a certain date, you usually, I mean, it depends on your state, but in New York, for example, you have 2 years and 6 months from the date of the malpractice or the mistake to then file a lawsuit. So if you file a lawsuit, the insurance was in effect on the date that he made the mistake, right? Whether he was doing an operation or he failed to diagnose like cancer or whatever the mistake was, right? It was on the date of the malpractice. He had insurance. That insurance policy is still in effect. And let's say that was in like 2022, right? So I file a lawsuit now. Now we're coming up on like 2 years. I still have 6 months. I can file a lawsuit now. And then say before the lawsuit even gets answered, like in 30 days, they're supposed to answer my lawsuit, like in November sometime if I file a lawsuit today. But like before the lawsuit even gets answered, the defense lawyer calls me and says, you know what? The doctor retired. He moved to Florida. He retired. He's not a doctor anymore. It doesn't matter. I still have the insurance policy. He was a doctor on the time that it happened. I have the lawsuit filed. The case is within the statute. Whatever his policy limits were, they're still in effect. So you're totally fine. It doesn't matter. As long as he wasn't like retired and didn't have, if he was retired and didn't have insurance on the day that he's doing the surgery, making the mistake. Now that's a different question. I don't know. Hopefully that's not the case. Okay. And then Frost says, did any of your cases almost get physical in court? I'm sure serious injury victims get furious when insurance tries to lowball in a serious injury, life-changing case. Oh, physically, like they're going to start fighting or something? No, nothing like that. I mean, not that I could remember. I know those politicians sometimes fight, right? The ones in like Europe or something, you see those videos and they start fighting in the Congress, I think out in like some of those countries. But no, not in court usually because they have the bailiffs. But I mean, sometimes people do get upset. Sometimes cases get lost and you think that they're going to be won. And sometimes it's vice versa. You think a case is worth a certain amount and the jury gives much more. So we just try to do the best. You get as much as possible. And, I'm always mindful of like, if I have a real offer, it's like real money. You got to tell the client and you have to advise the client properly, because if you have real money, the client could take this money and it's real money in their pocket, as opposed to getting a verdict, which is just a paper judgment, right? You could take a verdict for like 20 million and they'll say, great, you got a verdict of 20 million. Now what? Now we're going to file an appeal. The appeal is going to take 5 years. And guess what? The appellate division, which tends to be more conservative, is not going to just allow the 20 million. They're probably going to say, it's not reasonable, and then say, do another trial, which is another $100,000 out of your pocket, plus another, month being in court, plus it takes a wait to get to the trial, right? All that. And then you don't know what's going to happen there. So, kind of like, what do they say? A bird in the hand is worth more than two in the bush, right? Somewhere, because they're in the bush, they just fly away. But if you have it in the hand, you have it. So I kind of like also advise my clients about that. Like, for example, the case I had last summer, I was in court and it was a good case. The guy was really hurt, but it was a pre-existing injury. So he already had an injury. The injury was just made worse by this fall. And so, plus the liability wasn't great because it was contested. And one of the witnesses, who was supposed to be impartial and powerful actually turned out not to be so credible, especially on cross-examination. So given all that, we already had, like, after the witness, we talked turkey with them, and we got up to $3.5 million. And that's like serious money. So I said, look, I mean, we can take $3.5 million, like bird in the hand, or we could go and try for like 15, 20, but then they're going to appeal. And he couldn't wait anymore. The poor guy was like about to be homeless. So he took the money, but it was a good settlement, but that's an example. So you have to always think about that. And then Aquatic says, does getting a surgery recommendation from a specialist hold weight and negotiating for a settlement? And how much weight does it carry in negotiations? Yeah, no, that's a lot. I mean, if you get a surgery recommendation from a specialist, that holds a lot of weight because that's exactly what's going to happen in court, right? So if a doctor who's a specialist in that field says you need a surgery, for example, a neurosurgeon says you need an ACDF, or a knee orthopedic surgeon says you need a arthroscopic knee surgery, that's what you need in court, right? So if the doctor would then come to court and testify before a jury and say, you know, I'm a medical doctor, duly licensed to practice medicine in the state of New York, and it is my opinion with a reasonable degree of medical certainty that this knee arthroscopy was medically necessary and caused by the car crash. That's all you need, right? So if you have that now, they know, right? The insurance companies, the defense lawyers know the standards, the legal, because they've done this before. This isn't their first rodeo. So they know. So then you say, look, you got to pay me, because if you don't pay me, this guy's going to testify and then you're going to pay me more, right? That's the whole idea. So yeah, absolutely. Absolutely. That holds a lot of weight. Like, in fact, I remember a story where I had a guy, he was an older guy. He was like close to 80, and it was only $100,000 policy. And he had a torn meniscus. It was like a car crash. And, you know, he wasn't going to do surgery because he was 80, but he had this torn meniscus, and they were offering him like $5,000. But then he went for a consult to an orthopedic surgeon just to see, you know, and the orthopedic surgeon said, yeah, this tear in your knee needs surgery. And so he just wrote a report. And I sent the report to the adjuster. I said, look, the orthopedic surgeon, the guy who does the surgery, saying he needs a surgery, and it's because of this accident. And then all of a sudden, she gave me a call. We settled the case for like $85,000. So it went from 5 to 85, almost like the entire policy of 100, just from that one report. So yeah, it holds a lot of weight. Those are great. And Nanette says, hello, thanks. How long does it take for an attorney to put together a demand letter? And are attorneys obligated to send a copy of the demand letter to the client? This is a mold injury claim. Yeah, I mean, they're not really, I mean, I don't know. Of course, it's your case, so you're obligated. It's not a matter of them being obligated. It's about, like, if you want a copy of the letter, just tell the attorney, because a client is entitled to their file, right? It's your case. An attorney is just like your guide, your counselor. So if you don't like the attorney, you can fire them and get another attorney, right? So yeah, you could look at anything in the file. Now, most attorneys do send a copy of the letter to the client. Some might not, because they get busy, they forget, but the client could totally have access to it. And yeah, so absolutely. And then Digital Audit says, is it okay to drop and switch your insurance company when you have a big open claim? I'm not happy with them and need to cut costs, but will it affect my open claim? Yeah, so if you mean that you have an open claim, like you're suing someone else, then yeah, you could drop them. It doesn't matter. Because, you know, again, just like the medical example with the doctor, I don't know if you listened to that a few minutes ago, it's the same, right? It's like, for example, you get into a car crash on a certain date, it's whatever insurance company you had on that date. They're going to defend you if you get sued, and they're going to give you, like, say, no fault benefits and pay your doctors so you can get treatment up to $50,000. That's the New York PIP law. So it's like, say I had Geico on January 1st, 2024, right? I got into a car crash. I want to get medical care. I get it through Geico. I want to sue the other side. Maybe they're Geico too. So I sue them. It's all fine. If I then don't like Geico anymore in February, it doesn't matter. I fire them. I get Allstate. Now I have Allstate. It doesn't matter. You could do that. It doesn't really hurt you. And then Aquatic says, if I have the level 2 ACDF surgery recommendation from the specialist, but I'm scared to have that surgery, will that diminish the value of my case? The policy is $100,000. No, I mean, look, if you have an ACDF, need for an ACDF, you know, that's all you need. I mean, that should clear the 100,000. You don't need to have the ACDF. I mean, ACDF, if you have it, I mean, that's worth like 2-3 million. So if you only have 100,000, the need, just like my example I gave with the 80-year-old man, right? He didn't have the surgery. He just went to the specialist, and the specialist said, you need the surgery. And just that got it from 5 to 85. So if you get the same thing and they say, hey, you need an ACDF, you should get the full 100. I mean, I don't think most people, I mean, I don't know, I can't speak to most people, but unless you really, really need it, if you really, really need it, you might have it. But like, I haven't really seen in lawsuits, I haven't really seen too many people getting ACDFs just on a 100 policy or 25 policy. Usually, you know, for lawsuits, unless it's like, you know, they're going to have it not because of the case, but they're just going to have it for their health. Of course, then you're going to have it because you need it. But in terms of cases, you know, usually you see ACDFs with larger policies, like with trucks, with construction accidents, with ceiling collapses, because just the cost of an ACDF is like 100,000. So how can you have it for $100,000 policy? You know what I mean? It's hard to make it happen. It's just, you know, because the cost of the surgery is from 50 to 100,000. So no, I wouldn't worry about that. I mean, there is, on the flip side, I mean, just so you have the full information, there is something known as failure to mitigate damages. So for example, if a doctor says, hey, you have to do this surgery to feel better, and this would make all your pain go away, and you say, no, I don't want to have that surgery, that could diminish the value of your case. But that's usually for bigger cases when you have larger policies. That's a failure to mitigate or lessen your own damages because you're not listening to the doctor. But this isn't really that case because, you know, you're talking about a 2-level ACDF. That's a major life-changing spinal fusion. And if you choose not to get it, you're still okay with 100K policy. And John says, can having insurance help you in an injury case, even so the person who caused the accident is paying for your injuries? The person who caused the accident is paying for your injuries? You mean paying like personally? Or usually the insurance would be paying, not the person. I mean, you sue the person, like for example, the person rear ends you, right? So you sue the person like John Smith, but it's his insurance that actually pays, like Geico, Allstate, whoever he has, Chubb, Progressive, you know, that's usually how it works. But if you have insurance, it helps you. It depends. If you have a no-fault state like New York or Michigan, then it helps you because then if you have insurance, you get PIP. And so, like, for example, if I get into a car crash here in New York, right, I'm in my car, I have Geico, let's say. I'm stopped at a red light, and Allstate car hits me in the rear. I didn't do anything wrong. The Allstate car hit me in the rear. I'm stopped at a red light the way I should be. But it's my insurance, Geico, that has the no-fault of $50,000. It acts like health insurance. So if I go to the hospital, I go to the doctor, I get physical therapy, Geico is going to pay for all that, right? And then same thing with lost wages. If I break my glasses, they're going to pay for my glasses. You know, there's all these things that is covered by no fault. And then, of course, if I'm injured, I'm going to sue for the bodily injury, for the pain and suffering. I'm going to sue the defendant, which is Allstate. So that's how it works. But yeah, some states are different. Some states don't have no fault or PIP. So then you end up having to, having to sue for your medical bills. So it just depends on what state you're in. Okay, so we did John's question. Nanette says, how much is a mold injury claim worth? It depends on the injury from the mold. I haven't done too many mold cases. I know a lot of the insurance policies also exclude mold. So then if there's no insurance, that could be an issue. So you'd have to really do a deeper dive into the case to tell you. But if you have a lawyer handling it, you should ask them. They should know. And then 777 Blessed says, yes, hi, in Florida. If I start my case before the 2-year limitation, is it still good if you go beyond this 2 years after if I have to file my claim? Yeah, it's fine. I mean, look, I'm not sure I understand the question, but basically the 2-year statute of limitations is a deadline just to file the summons and complaint. So then, as long as you file the lawsuit before the 2-year deadline, right? Because if you file it after the 2-year deadline, the statute of limitations has expired. Deadline is gone. It's too late. They won't. It's like garbage. It's like a nullity. They'll just, they won't entertain it. So you have to file the lawsuit before the 2 years deadline expires. That's all. After that, you do whatever you want. You continue the case, litigate it. There's no more deadline. Once you file it, the deadline disappears, right? The deadline is just to file the lawsuit. Lorenzo says, what if I have a settlement pending and I get into another car crash a month ago while recovering, causing more PTSD and pain returning? Both drivers had the same insurance as well. Yeah, so you could do the second case. The first case, you already had a settlement, right? So then I guess that's done. That's settled. But then you just do the second case. You just start that. Aquatic says, thank you. Oh, you're very welcome. Thank you. Kenzie says, Arkady, I want to know if you have a rear end accident case going on and you slip and fall and sue the supermarket. Can these two cases have conflicts with each other? No, I mean, they should be okay. The only issue sometimes is if it's the same injury, right? And they're each going to point the finger. Like I was telling a client, I had that happen with a client of mine. He has a truck crash and he has a serious injury from the truck. And then he got into this little accident more recently and he wants to sue for this little accident. I said, look, you can't really do it because look what's going to happen. The new case, they're going to say, well, you're already hurt because of the truck. And then the truck is going to say, okay, you were hurt up until this date, but now you have this new thing and now you're treating for that. And it's all this car crash that you had. So your future damages stop, right? And you don't want that. You want to, so you have to evaluate everything and kind of like build it the proper way. So I'd have to know, you'd want to know like how much insurance there is on the car, how much insurance there is in the supermarket, what are the injuries. The best case scenario would be if it's really clear, right? For example, when you had the car accident, let's say you had a left knee meniscal tear and you need surgery for that. And that's your injury from the car accident. But then when you had the slip and fall in the supermarket, maybe you fell and you broke your right wrist, right? It's a completely different body part, nothing to do with each other. That's fine. But if it's the same thing, if it's like the both, neck, like herniation, and for both, and it's going to be like a soup. It's going to be hard to untangle. Okay. And then Hector says, I follow all the videos. They are great. I just want to give a video suggestion. The title is, which cases are solved earlier and which are solved later? You are doing great work. I'm grateful for that. Oh, I see. Which cases are solved earlier and which are solved later? Yeah, I like that. What do you guys think? You like that? I like that. That's good. Yeah, we could do that. We could do a video. I'd have to think about that and outline it. But yeah, I mean, some cases are solved earlier. Like, for example, I once settled a case in 4 months from the date of the crash, meaning there was a car crash. The person went to physical therapy for 3 months. They stopped. They reached maximum medical improvement. They didn't need any more care. The medical records came in. They said, I'm going back to work. I'm fine. I sent it to the insurance company. I got on the phone with them. And within 4 months of the crash date, we had a check. It wasn't huge. It was probably like 15,000, something like that, but it was settled. And then, of course, if you're going to litigate a case and you're going to go through court, and it could take like 5 years, right? So it's interesting. Yeah, we could do something like that. The types of cases, the types of injuries, and maybe some of the other factors, like when you're in discovery, sometimes you get stuck in discovery, or you get some kind of roadblock, and it leads to delays. That's a good topic. Yeah, thank you for sharing that. And Positivity says, if a trustee is involved and is the one paying out all the parties involved, how long does it take to issue out once they've received the settlement check and the judge has approved for disbursement? Oh, so you mean like a trustee, kind of like a bankruptcy or something? Well, if everything is approved with the trustee, with a bankruptcy, you have to get court approval. So if the court approves it and the trustee and the court give you the order and everything's done, they just send the check. It shouldn't take long, whatever it takes, like a week or two. But if the whole process could take some time if they're still evaluating or reviewing something. And then 777 Blessed says, you rock. Thank you for your videos. Oh, thank you. Thank you for watching. And Burnt Salid says, please explain a proposal for settlement in Florida. Yeah, well, I'm not familiar, with that term. I know like a lot of different states have different terms of art. So it could be the same thing, but they're called different things depending on if you're in California, it's called one thing, but in New York, it's called something else, but it's the same thing. But a proposal for settlement, I would guess, would just be like either just what it sounds like, right? I'm proposing a settlement. So for example, I'm giving a letter and I'm saying, hey, let's settle this case for 100,000. And they say, okay, let's do it. Now you have a settlement. But before we had a settlement, which is the agreement, it was the proposal, right? Just like if I send you a proposal and I say, hey, here's a proposal. I could, fix your house for $10,000. You say, that's a great price. I'd love to fix my roof or whatever for 10,000. I'm going to sign this proposal. Now it's a contract. Now we have a deal. I'm going to come and I'm going to start fixing your roof, right? Just like that. It's just a proposal for settlement. So a plaintiff could make it as a demand, right? I want to settle the case for $1 million. Or a defendant could send you a proposal and say, hey, how about we settle this for 100,000 or whatever? So yeah, I think that's what it probably is. Now in some states, I don't know if you're really asking this, but in some states they have these issues with, like in California, they have something called a 998. So for example, if the defendant says, I'll give you an offer, let's say for 100,000, and you say no, and then you go to trial and you get less, like say you get 50,000, you had a chance to settle for 100,000, but you said no. So now because of that, you may have to pay all their attorney's fees and costs. I think that's called a 998 in California. We don't have that in New York. In federal court, they have something like that too, called an offer of judgment. That's also something that could then hurt the plaintiff or the plaintiff's attorney if they choose to, not take a proposal that's significant and then it ends up being less than the proposal. But I don't know if you're asking about that. That's more of a federal court in California issue, or so other states have that too. I think it's called offer of judgment. Okay. And Shane says, how much is a concussion for an 18-wheeler case? Well, like I said before, it's hard to generalize, but a concussion, if it's just a concussion that goes away, it could be worth less. But if it's a real traumatic brain, because a lot of the more recent literature says that a traumatic brain injury is a concussion, and a concussion is a traumatic brain injury. Like in the NFL, these players, they're getting concussions, and then it leads to encephalopathy, even death. So yeah, if it's a real brain injury, it could be worth millions and millions. It just depends on, we got to do a deeper dive and look at the medicine. And then Digital says, is the statute of limitations the date and time of the crash or when the claim was opened? No, so yeah, it's from the crash, from the date of the incident. You have, like, say in New York, you have 3 years. So if I get into a car crash, let's say today, right, October 17th, 2024 at, let's say, they don't really look at the time, I don't think, like 5 p.m., right? If I get into a crash, I'm going to have until October 17th, 2027. I think, even if I file it after, like at 6 p.m. that day, even if I file it at 11 p.m. that day, I think I'm fine, before midnight. But if I file it on October 18th, 2027, well, now it's more than 3 years, right? Yeah, so then I'm in trouble. So that's how it works. And let's see. Glory to God. Thank you, Linda. Oh, you're very welcome. Gary says, after you file a lawsuit in New York, how long does it take for your case to go to trial in a settlement agreement? Well, there's no settlement agreement. Remember, a settlement agreement is like a deal. So like you guys reach a deal. Like, for example, I want $1 million. They're offering me 900. I say, well, we're close. How about we settle for 950? Okay, shake hands. It's a deal, right? We could do that at any time. You could do it before you even file a lawsuit, as long as everybody agrees. But you could also do it at trial or during trial or even after trial, right? You could do it at any time. It's like a settlement is a private like contract, right? And then the trial, you're saying, how long does it take to go to trial? It depends where you are, right? In New York, which county, like Brooklyn, usually from after you finish discovery, you put it on the trial calendar, maybe about a year. Queens also, Manhattan also about that. Some places like Westchester or Long Island might be even quicker. Staten Island, I think, is pretty quick and efficient. But some places like the Bronx, you could be finishing discovery, put it on the trial calendar, and you might have to wait 2 or 3 years. So it just depends on what county you're in. And then Frost says, do lawyers take the settlement out of the policy limit settlement? I'm not sure what that means. Take the settlement out of the policy limit settlement. Well, if you get a policy limit settlement, that means they're tendering. They're giving you everything they have. So if the policy limit is 100,000, they're sending you a check for 100,000. So the lawyer just gets the check for 100,000. They put it in their trust account, which is a special account that the lawyer keeps for clients. The lawyer is then allowed to take his expenses. Let's say he spent $1,000 to prosecute the case, like file a lawsuit, do certified mail, takes his expenses, right? So now you have 99,000. he could take his third, which is what, 30,000, right? His legal fee out, and then he disperses the rest to the client. Or if they're lien holders, like if you have doctors who have liens, or you took funding, you have to pay back the funding company. He pays those people and he gives the client their share. There should be like an accounting statement of everything. That's how it works. And then the net says, thank you, you're awesome. Oh, thank you. Sani is here. Sani says, can the opposing side offer a settlement during or after the deposition? Yeah, they can. They can, absolutely. Even before the deposition. I had a case like this week. I mean, I don't want to say too much about it because I didn't, it's not done yet, but they settled the case without even a lawsuit. And it was a multi-million-dollar case because it was in another state. It was really bad injuries. And I was partnering with another lawyer on it, a group of lawyers. They're really good lawyers. In fact, they are on trial, I think now on the West Coast in some cases that could be worth hundreds of millions. So they're really good lawyers. So as soon as the other side, and it was funny because the lawyer for the defense knew, they had another case together. So the lawyer on the defense who's handling the defense on this case, who would be handling the defense had they filed the lawsuit. I guess they sent a letter so they knew who it was. So, knew these guys. So just the fact that he saw these guys coming into the case, he was like, okay, here's everything we have. And it was like, many, many millions of dollars. He just said, here's everything, every last penny, because he knew their reputation. So that just shows you how a real trial lawyer can really, kind of like part the Red Sea or whatever, really make things happen. And just really, because another lawyer would be litigating that case for like 10 years and then like pounding their head against the wall, and they, I haven't seen that too often. So I was really impressed, but they just gave everything that they had as soon as they heard who it was. So let me see. Jesus says, how often should I talk or should I meet with my attorney? Well, yeah, whatever you feel comfortable with. If the attorney's communicating with you, you could just communicate on the phone. You could text. You could do Zoom calls, video calls. You could meet in person, go to their office. You could, if the case is going to trial, then the attorney should be talking to you more. Maybe they should come to your house, interview you. Depends on what you feel comfortable with. And Burnt Slide, what do you think about this injury osteochondral pension of the talus of the dome? What is it worth? Oh, osteochondral of the talus. I believe that's the foot, right? The talus. Pension. I'm not sure what pension. Pension is an injury. That might be misspelled. I could look it up. I could let you know. If you text me the actual injury, I could do a verdict search and I could send you the results. But I would say osteochondral, like, talus, some kind of like fracture of the dome, something like that. I think those are usually at least a few $100,000 just from off the top of my head. And Jesus says, I only seen my attorney once in the last 3 years since my case started in 2021. Is that a good thing? Should I be meeting with my attorney every so often? Yeah, I mean, if you only saw him once, that's maybe not so good. If you feel like you have a big case and, it's like a life-changing injury and you want to get millions and millions of dollars, well, it's like anything. You get what you put into it, right? If I have a flower and I water the flower and I take care of it and I give it sunlight and I get all the, Miracle Grow, whatever, the flower is going to be strong. If I just leave the flower alone, I never see it, I never water it, I put it in the basement, it gets no sun, it's going to die. It's the same thing. It's like anything. It's just use your common sense. But whatever you feel comfortable with, it's a little bit of a different dynamic, right? Because you're a client, right? So you don't know all the legal, you don't have the legal knowledge that a lawyer is going to have. So you just kind of trust the lawyer. But if the lawyer is then abusing that trust and just kind of like making money or doing like high volume cases and not actually working on your case, then you get screwed over. So you don't want that. So you got to like keep tabs on that, make sure that they're doing what they should be doing. And he also says, how often will the defense settle in Westchester? Yeah, I mean, we just had a case in Westchester. We settled. I mean, it was a case actually that we took over from another lawyer. We ended up getting, what did we get on that case? Like 600,000, close to 600,000. And the other lawyer, I think, only had like 100. So we did pretty well. But, it had some issues. So we ended up not trying the case. But we were ready to try the case. And it was up to the client and what the client wanted to do. But yeah, you could do well in Westchester. You could get good money. Okay, we've been here a while. Time flies when you're having fun. We've been here for like an hour and 15 minutes. So I better run. But thank you, everyone. Thank you for being here. Thank you for watching. I love, sharing knowledge and helping people. And I'm so glad that people are enjoying this. And I see we have like 53 people here. So that's awesome. That's a lot of people. We have all these questions, like hundreds of questions. So that's awesome. But yeah, we'll do more videos next week. I'll try to do another live or two next week, but I'm going to do a few more recorded videos and try to give you some value. And remember, like, you could come on these lives and you could leave a comment like you've been doing, or you could also put in the comments that you want an actual live consult, and then you just text me your number and I would call you, and then I would do the live, consult. But there would be, I mean, obviously everybody would hear it. We'd be here live, right? But you don't tell me anything confidential. It would just be like what happened, the facts, just generally what city you're in, and what your injuries are generally. And we could talk about any questions you have and do a live consult. That way it's not just me talking. So yeah, if you want to do that. I did that on the last live and I think it was pretty helpful. Okay, everyone, have a great day. Our goal is helping serious injury victims and families. We're here for you. Please like and subscribe to our channel. We're almost at 10,000 subscribers. We want to get there at least before the end of the year, maybe even more, maybe earlier. But thank you so much and have a great night and stay safe out there.